fallout from Hudson. This idea that we look to the purpose underlying the constitutional right we're trying to assert in order to determine whether we're going to apply the federal exclusionary rule. Hector. Hector's a case where the officers failed to leave the search warrant. It's required under statute to leave the search warrant with the occupant of the premises. What the Ninth Circuit said was, even if that were a constitutional requirement under Hudson, that has nothing to do with protecting the privacy of the house. Doesn't matter whether you comply with it or not. Under Cesares Olivas, the Seventh Circuit, same kind of, this is one of the Title III, the federal telephonic warrants. And you have to reduce a telephonic warrant to writing after you've, but it's too late for anybody to read it, but after you execute it, it's got to be reduced to writing. They didn't do that. They said, well, that the purpose in that, like in Hudson, was not to protect the privacy of the individual. What the fuck was it to protect? Anyway, U.S. versus Cost. This is an interesting case. This is a 10th Circuit case, and this is a case where they rely on the consent of the person who's present. And they said, remember, under Schneckloff and those other cases, they can rely on the consent of someone who has absolutely no right to give it, as long as they're acting reasonably. They said they were unreasonable here. You ought to just read the facts of this. It's hilarious. They walk in, the guy said, fuck, it's not my house, I don't give a shit what you. So they said, okay, I guess so, well, they relied on that kind of consent. But what's interesting is what the 10th Circuit said. They said, we view Hudson as being limited to the knock and announce requirement. I'm not sure that other circuits are going to do that, but it's a good case. All these are in the materials, too, by the way, folks. U.S. versus Rice is an interesting case because it deals with a wiretap, a Title III wiretap. And what the Sixth Circuit says in Rice is, look, the Hudson exception, look to the purpose, the good faith exception under Leon are both judicial nuances based on a judicial remedy. The Constitution doesn't say you exclude evidence obtained illegally. That was a judicial remedy in order to protect our rights of privacy. So they said, well, that was judicially created under the whole clause, so these judicial nuances, but Title III, federal wiretaps, has its own statutory exclusionary rule. Therefore, neither Hudson nor the Leon good faith exception apply to Title III warrants. Oscar Torres is a more interesting case. This is a case, remember Davis versus Mississippi. Remember it was a classic case. There's a rape of a white Anglo female, elderly female, and all she can tell him is it's a black guy and he came in through the window. There's a couple of fingerprints on the windowsill. They go up, round up all the black people in this small Mississippi town, take all their fingerprints, and match one up. And the Supreme Court says, you can't do that. You got to have probable cause, at least reasonable suspicion to stop somebody, probable cause to arrest them, and you had neither in this case. Well, what they're saying here is that fingerprints that are taken routinely as an administrative process, under Hudson, they're not excluded. But if the fingerprints are taken for an investigative purpose, then they are. And what's interesting about what they say is that, for example, when they stop undocumented individuals, we know that although it's an administrative process to take down their fingerprints, what they're really doing is trying to look for some excludable offense. So there's a criminal investigative purpose. And they said, even though that was an administrative type of fingerprint, the purpose in the officer's mind was more investigative, more criminal investigative in nature. Breaking Virginia versus Moore. By the way, and I'd like to see it, we're going to get to it in a minute, but think about that. Remember how the Supreme Court said we never looked at subjective intent? Bullshit. Okay, Virginia versus Moore. This is from 2 months ago, and another crushing blow to the Fourth Amendment by the new court. Remember New York versus Belton? How many of y'all remember the Bright Line Rule case? Remember, you can search the entire passenger compartment of any vehicular stop, so long it is what? A custodial stop. All right, that's the rule. If it's a custodial arrest, then you can search the entire passenger compartment. Well, what's interesting is this Chubbs Moore is driving down the road. He's got a suspended license in Virginia. They stop him and search the passenger compartment under Belton's Bright Line Rule. The problem they have is, under Virginia law, you can't arrest somebody for a suspended driver's license. You got to ticket them. Well, what does Scalia says? He says, well, hang on. We're not going to use the federal exclusionary rule to enforce state law. All right? And therefore, Chubbs Moore is doing his time. Again, he looks to the original intent. This is how he decides it. He says, we look to the common law of the founding era to determine the norms that the Fourth Amendment was meant to preserve. And he uses language like, you know, they had general warrants and writs of assistance. Remember, the King George's redcoats had some leather writs of assistance. They just go bang down your front door and rummage through your underwear drawer. Well, you know, that's interesting to go back and look at the norms of the common law at the founding moment of this country. But quite frankly, intrusions into our right of privacy are a little more sophisticated today. You know, there's nobody banging down our door all the time. Some of that new technology is stealth-like. They're stealing our thoughts, not our underwear. You can't feel it, you can't see it, you can't taste it, and perhaps it's more dangerous and more sinister because of that. Because what it steals from us is our thoughts. It steals something at the crossroads between our Fourth Amendment right to be free from unreasonable searches and seizures and our First Amendment right to free speech, to right of association, to right to bitch about our government. And that has a chilling effect on the citizenry. And I'll be damned if that was anything that the Founding Fathers thought about. They thought about a chilling effect, but they had no idea they'd be able to look through walls or listen to conversations many miles apart. That's something that Scalia fails to understand. And by the way, state law is interesting. Virginia doesn't have an exclusionary rule to exclude state law violations. Why not? Because they didn't think they needed one. They were using the federal exclusionary rule until Scalia says, I'm sorry, can't use it. Texas has a statutory exclusionary rule. New York has a statutory exclusionary rule. Several states have constitution. Alaska, Arizona, Idaho, Kansas. The list, what I loved is the only one I could, don't you love California? They have a constitutional amendment, truth and evidence provision of their state constitution that says states are precluded from excluding relevant evidence because you violated the state constitution. You know, poor fuckers. I mean, that's what happens when when people aren't paying attention, they're just pulling levers. Constitutional amendments ought to be more than simply a referendum. Scalia's reasoning, again, you can't have the exclusionary rule depend on the vagaries of state law or rules that are different for every state. Well, fuck, that's exactly what he left us with. You know? I mean, every state's different. And he says, well, you got to have consistency. You know, what I don't understand is it too much to expect New York law enforcement officers who are charged and sworn to uphold their law to know what the law is and to abide by it? They expect us to. Even if we don't know what it is, English law don't teach. Even if we don't know what the fucking law is, they expect us to abide by it.